Good afternoon. I want to share with you the repercussions of a fee petition. For those of you that you may or may not know, a fee petition is the second way attorneys and non-attorney representatives who represent claimants before the SSA officially as appointed representatives, how they get paid. Okay, so I think many of you know that, and hopefully the rest of you will know, no attorney or non-attorney rep can charge you a fee for representation officially before the SSA without SSA written approval. And that comes after generally you have prevailed. Okay, so don't ever expect a bill along the way. I've heard situations from people I've met who had attorneys that must not have practiced Social Security law as a regular thing and were just dabbling, and they were sending them billable bills and they had to come up with, one lady, it was about $16,000 over about 4 years. So anyway, not acceptable. Okay, so as you know, there's the fee agreement that you sign when you retain a representative, attorney or non-attorney. That is the contingent fee agreement. Many of us are now using the SSA's drafted version of it, which is called the 1693. Prior to that, most of us, for sure, had our own proprietary drafted legal fee agreements, and we just had to make sure that the language and the actual fee amount jived with the mandated language or paraphrasing that the SSA required. And that would be the 25% of back benefits capped at whatever the legal cap at that time is. And most of those agreements had a escalation clause. So when the legal cap would increase, which was extremely rare back in that day, it's supposed to be changing soon. The fee would pivot accordingly. So if you're awarded after a fee increase, you would be paying the increased amount. And then, of course, for most of us that practice this religiously, we are registered with the SSA, and the SSA has our bank accounts and does a direct withholding from the back benefits to pay that 25% of back benefits capped at the cap and sends it directly to the lawyer or the non-attorney rep so that you don't have to worry about a bill. And then you, as the winning claimant, get the balance of the back benefits, which would be a minimum of 75%, but could be much, much higher percentage-wise. Okay, so then there is the fee petition. That will happen when the fee agreement fails or there is none. Let's say the SSA forgot to file it, process it. That's happened. It's ridiculous, unacceptable. You'd think they would have some remedy for that when you prove that you sent it in. But anyway, and then you as a claimant don't get the benefit of that fee agreement that you executed with your lawyer because the SSA won't approve it because they didn't process it before your award, whether they lost it, sat on it, whatever. Okay, you don't get the benefit of that fee agreement, and you do not get the benefit of the percentage or the cap. None of it applies. This is unfortunate. The contingent fee agreement was designed to protect claimants while still hopefully allowing enough livelihood to be made by attorney and non-attorney reps who care about this field so that they could stay in it and make a living. Okay, so the alternative when there is no fee agreement, and whether it's lost, was never filed, was never executed, whatever, if there is none, then the fallback, or there's no back benefits from which to collect 25%, even at $500 of back benefits to collect the $125 that would be the attorney fee, then the alternative method is the fee petition method. Fee petition is where the attorney or non-attorney rep has to itemize everything that was done in the case and send a list along with the 1560 that kind of summarizes what the total amount is. And the SSA then reviews that over the course of the next months or years and decides what they're going to agree a fee could be. In theory, if they haven't withheld the money to pay that fee by fee petition, then there's low chances less able claimants who have prevailed will be able to pay a bill anyway. Sometimes there are payment plans, $10 a month for the, very poor. I know with us, if it's SSI and there's no back benefits to that claimant, we waive the fee. But that's not something we do necessarily by design and plan, you know, there's planned pro bono, and then there's pro bono that just happens organically that we have to always know is going to happen. Okay, so here's what I want to get into about the fee petition. Another instance where you're going to be faced with a fee petition. If you terminate, or your attorney or non-attorney rep terminates the representation midstream for whatever reason, that fee agreement that you had with them is no longer there to protect you. It gets tossed to the wind. So now the rep has to file a fee petition for all the hours that they did, and with little descriptors and everything. And the SSA kind of knows what was done. Not so much phone calls and messaging back and forth with client and attorney, but they're going to know what was filed, what was sent in. They should know anyway. You know, if the attorney is sending in medical records, and letters and correspondence and argument or whatever on initial recon, or subsequently even at ALJ, the SSA should see that, and therefore, you know, they'll see it in the list, but they should also see it in the file, presumably if they're looking. So you have a full-blown billable fee petition, whatever the attorney charges, which presumably is a few $100 an hour. And the cap that would apply to the fee approval that the SSA would give on your contingent fee agreement that no longer applied does not apply to the fee petition. I believe there is a much higher potentially cap, but I don't even know what that is. And the reason why I don't know is because the few times we don't do fee petitions a lot. We don't like them. However, the few times we tend to do them is not because there was a withdrawal of representation, although that has happened 3 or 4 times in my 20-year tenure here. It is usually because there is either no back benefits for whatever reason, and we've made the decision that we're still going to have a bill. The person go on a payment plan. That would tend to be a wealthier person, and there's no reason for them not to have a bill now that they've prevailed. Or the SSA, for some reason, got a cog in their wheel and disapproved the fee agreement or denied that they ever processed it. You could have proof you sent it in 3 years ago and that they got it, and it doesn't matter. So that's when a fee petition is. And in those situations, what I do, and this is not required of any other lawyer, everyone does their practice their own way. I do voluntarily limit my fee petitions in those instances to whatever the cap was that would be in the fee agreement, even though the fee agreement doesn't apply anymore and the cap wouldn't apply, and I can technically ask for all the hours to be paid at the regular billable hour. I do that because ethically, to me, or morally, my client and I had an understanding that the fee agreement was going to prevail unless there was no back benefits. And if there was back benefits and the SSA dropped the ball, why should my client be held to pay more when this is what we personally agreed to? It's your word, mano a mano, right? So that's what I do. And I use the same cap. The billable hours always are far more than what we'd ever get paid on the fee petition. It just is. I mean, the fee petition method of the SSA, which I appreciate, it is what, you know, keeps a lot of attorneys who feel the need to have a much higher stereotypical lawyer wage. It's what keeps them out, because it is a very discounted fee. So the goal, of course, is for those of us that love this area, is do your job well, do it thorough, win as close to all your cases as you can. That's not always possible if you're the type that's going to go out on a limb and help people that have disability but poor legal cases. And some of us do that. It's a challenge. And we accept the hit we might take. But some of us think that everyone who is disabled deserves a chance. We can't help all of them, of course, because there's not enough hours in the day, but we're working on that. So, fee petition. If you want to, I have a video on the ups and downs of if you're deciding to get rid of your attorney, or you found that your attorney or non-attorney rep wants to terminate the relationship. which is doable by either side at any time. Well, I take that back. The attorney might not be able to get rid of you if you're pending hearing. So usually we try to know before we get to that point if there's going to be a reason to extricate ourselves from a case. But that's a whole nother thing. If you do have a terminated relationship or you terminate yourself and you get another representative, here's another little ditty for you. Your attorney that you just are terminating with now is going to be submitting a full-blown fee petition. And so is the next guy. And remember, you don't have that little pretty cap of 7,200 or 9,200, whatever it is by the time you're watching this. You don't have that cap. So in theory, you know, both are going to be asking for whatever work they did on it full blown. Now, do I think the SSA is going to award them all full blown? No, they're going to be looking at what your benefit amount is. Did you get back benefits? They're not going to be digging into your personal finances because they don't have a right to do that, I don't think. But they will try to mitigate a bill. I believe they will consider how big or small your benefit amount is. If you are a high income earner and you have a $3,500 a month benefit, they're probably going to presume you have some wealth under your belt. Otherwise, perhaps some retirement, whatever the case may be, that you have more wealth and you can actually pay your bill. Will they do the full amount? Still probably unlikely. Where will they draw the line? Don't know. Because again, I have not really had many of these. I'm doing one now due to a situation that occurred here, but I want to say it's like 3 or 4 times, and well, we're at like year 19 or 20. So don't know where that will fall. Don't even know if it's collectible. I would think that what I would probably just do is if the person doesn't pay it and they got back benefits, I'll send it to collections. I'll just sell it, perhaps. I don't want anything, I'm not a collector. I will perhaps shuffle it along to someone else, which I haven't done in the past, but I might. It really depends on the relationship I had with the client. And again, I too would take into consideration their wherewithal. If they're sitting on a big chunk of back benefits that I was instrumental in securing for them, I'm going to be less likely to be like, oh, okay, I'll just walk away. And part of the reason for that is you really don't want to give an incentive to bad actor claimants who are used to spending money on credit cards, not paying them, or going on a vacation and, borrowing money from whoever and not paying them. It's all the same thing. It's kind of like a theft of services. If you could pay it and that person did the work, honestly, for ethical reasons of our own, we should all be, trying to pay that. One thing we also do with fee petitions is, particularly in the nice arena where they occur in, not the preferred arena, but when it's just, the SSA screwed up and there's no interpersonal differences with a client, I will, it's been more than once where I've been like, what do you think the fee should be? Seriously, like, what do you want to pay? And the person will tell me, I'll be like, okay. Or I think that's a little high. Let's go a little lower. I mean, I'm a weird bird. But yeah, sometimes I'm just like, I would rather see both of us walk away fully satisfied and loving each other forever after than being a stickler for a few extra thousand. It just doesn't make sense to me. That's just the way I roll. I'm low maintenance. Okay. Anyway, fee petitions. That is what you're going to get stuck with if you part company with your lawyer or your attorney rep, a lawyer or non-attorney rep. And if you have more than one or you had 3, beware. You could peaceably get multiple fee petitions where they're all asking the SSA to approve their fee or approve some sort of fee. And then you've got that on your back. Okay. All righty. Talk to you later, guys. Bye.